Dr. Khare, Mishi Agarwal, the organizers. I hope I'm clearly audible to you. Yeah. The organizers, and of course, dear students. Thank you for this invitation. I don't know what I've done to deserve it because, as you heard in the introduction, there was no mention of any animal rights related work that I might have done. So I'm not sure why I'm here, though I have done some. I'm here to speak to you about Article 21, Animal Rights and New Cultures. It's a topic I chose because the new cultures part is of interest to me, and I'll try and develop it as we go along over the next half an hour or so. It strikes me that the Constitution itself has no express mention of animal rights as such. There are passing references in directive principles and duties and so on relating to the conservation of wildlife, the duty of compassion to all living creatures, etc. But as is often the case with much development in public law, the interpretation of such rights falls back on the court under Article 21. A simple article in itself, but one that has been stretched and interpreted in many ways, in many directions. Now, Article 48 of the Constitution is interesting because it mandates a directive principle that requires the state to work towards the prohibition of cow slaughter. This is one express reference to an express animal. It makes me wonder why only cows, right? If we're speaking about a larger animal law regime, surely it goes beyond cows. And the Constituent Assembly debates make for an interesting reading because this was really a to and fro that went on between a sort of rationalist and a more idealist faction of the Constituent Assembly, and ultimately arriving at this requirement of a directive principle for the prohibition or the protection of cows. But this became the sort of the window for some states to legislate on cow slaughter. And Bihar did it. It went up to the Supreme Court twice. On both occasions, the Supreme Court upheld the actions of the Bihar government. And thereafter, Maharashtra did it, as many of you know. And the challenge went to the Bombay High Court. The Bombay High Court upheld the act, but with two exceptions, striking down two sections. One of reverse burden, of course, and the other, interestingly, of the possession of beef when procured from outside the state. And it was in the striking down of this particular section that the Bombay High Court said something very interesting, which was that your right to food is part of your privacy, and in a sense, your right under Article 21, and therefore the state had no business to impede upon it. And for me, this is an important cultural conflict that one has to begin with. That what is the motivation of legislatures while dealing ostensibly with animal rights, while dealing ostensibly with the rights of cows, or the prohibition of slaughter, or kindness, all utopian principles, what motivations really drive legislatures to this end? And if it's indirectly a form of some sort of religious imposition, cultural revanchism, or even for that matter, simply moral policing as to what citizens must eat, not eat, wear, not wear, etc., then I'm afraid there is a conflict here inherently when it comes to this question of animal rights and Article 21. We cannot get emotionally blindsided by many of these issues because they overlap and they intersect with many other issues of our socio-political reality that we cannot lose sight of. It's fairly utopian to speak of, a certain type or a certain quality of food. But please remember, access to food is also part of Article 21. And how far have we gone as a nation on that front? If you were to read the compelling book by Shahu Batole called The Dalit Kitchens of Marathwada, because it's a fascinating book, because it brings Dalit cuisine to the mainstream in a sense. But at the backdrop is the politics and the deprivation of certain communities in India who've not had access to food. So it's all very well to say, eat a particular type of food and don't eat another. But first and foremost, let's ask the question as to whether all of us Indians have access to food or not. And there, I think this cultural intersection becomes one of interest. I want to take this a little further. And of course, on the element of cow protection, it strikes me as ironical that the response to cow protection has been mob lynching. How ironical is that in a regime of rule of law? I'll leave that thought there. But I want to take this conversation a little further. Maybe now I can speak about a case that I was actually involved in. That justifies my having been flown down to Cuttack. I don't know how many of you heard of an order of the Supreme Court, must be 10 years ago or so, where one fine morning, all safaris into forests in India were banned. And we love this idea of banning, right? Ban stray dogs, the dogs are the elephants in the room. I will come to them. Ban this, ban that. That's besides the point. One morning, the Supreme Court made an order banning all safaris in all wildlife parks in India. Now, this came as a bit of a shock because at that point, my practice was in Karnataka. Karnataka, many of you will know, actually has a fine tradition of wildlife safaris. And some of the best maintained and managed drives into the forests, in my experience, are in Karnataka. But because of certain rampant abuse, no doubt in some states, I think in Madhya Pradesh, in Pench and so on, where there was gross violation of the integrity of the parks, the safety of both the tourists and the animals, private vehicles. For example, in Tadoba, when I visited at one point, you could sit in your own vehicle, take a security guard with you and drive into the park, and people were blaring Bollywood music while there were tigers walking by. It was obnoxious. So I can see what provoked the Supreme Court. But the fact is, this was not happening across the country. But here was the remedy, which was prohibit all tourism / safaris in India till further orders. Now, this had a very different spiraling effect. And this is where, again, the cultural and the social intersection comes in. Because when you make drastic orders banning something, the spiraling effect is something that the courts often don't notice. With the prohibition on safaris, there was an almost immediate increase in poaching, because tourists, naturalists more than tourists, who love the forests and love the animals like their own, were suddenly pulled out of the parks. They were not permitted to be inside. So there were a lot fewer eyeballs in the parks, and there's only that much that forest officers can do, as many of you know, on foot treks and so on. So an increase in poaching, a greater risk to the animals, and of course, it goes without saying, the very serious economic impact on resorts, on safari operators, and the livelihood of the naturalists. So we had to then, on behalf of all these private properties in Karnataka, move the Supreme Court, implead ourselves there over a series of 3 or 4 very intense hearings, somehow have those orders modified and relaxed. The good thing with that order was that the National Tiger Conservation Authority really hit the ground running. I think that's what the Supreme Court intended. But the collateral was that for a period of maybe, I think, about 3 months or so, during the crucial Dasara period when you have more tourists, there was an economic impact. And as I said, there was in fact a direct impact on wildlife itself, which in a sense was counterproductive. And I still remember to this day, perhaps one of my most cherished moments as a professional lawyer, when I went back to Jungle Lodge's Kabini, all the naturalists who worked at JLR was summoned to stand around me, and then the manager said in Kannada, this was the lawyer who got the stay vacated in the Supreme Court, and I got an impromptu round of applause. That means more to me than any other accolade in my career. And that applause was not just because of livelihood and economic factors. I'm telling you that these naturalists, genuinely, their whole lives are based on the animals. They go in twice a day for 6 hours, 7 hours. They live and breathe the forest. The whole fetish of finding a tiger or a leopard or a wild dog or a bear is part of their existence, and they share that. If we're speaking of compassion, that compassion doesn't come to you naturally. I was not an animal lover when I was a child. I was agnostic to animals, to be honest. I had a dog, but it began and ended there. It was only when I started going into the forest, looking at different sorts of bird life, the fine coexistence in the forest, that I realized what this entire ecosystem is. So that's where, again, friends, there is an intersection of many interests that come into play between the law and the rights of animals and the larger questions of Article 21. I'm also reminded of one other prohibition that took place in Karnataka again. You know, the fish mashir, which is a beautiful fish, very large sized fish. There was angling that used to take place on the river. I was personally opposed to it because I thought that angling mashirs was not humane. It was basically game fishing and didn't belong. And at one fine morning, again, the government banned mashir angling. And I was surprised that the people who were up in arms against it were actually the conservationists. And when I spoke to them, friends of mine, they said, look, you have to realize that angling is a way of actually sustaining the mashir. Because angling is picking up the fish, weighing it, maybe taking a selfie with it, and putting it back in the river. Of course, the question that came to my mind is, does that angling not harm the fish? Is there not a hook going into its mouth? And I was enlightened. I don't know how far this is true, but a friend of mine who's a wildlife warden himself said that the mouth of the mashir is so muscular that it causes absolutely no damage. But please see the flip side. The moment the ban on the mashir came, suddenly that entire community of mashir lovers who went into the river or to the riverside were out, and then the communities living around the river started to hunt mashir illegally for food, because it was an excellent food source, right? And as a result, did this legal intervention really serve its purpose? And these are questions, friends, that one has to dwell on. They take me to larger questions of, for example, the forest dwellers' rights. As you know, the act that was brought in, again, ostensibly with the valuable objective of A, of course, maintaining the purity of the forest and the wildlife, and B, perhaps more importantly, recognizing certain limited rights in scheduled tribes and other forest dwellers. Now, you must remember here, friends, that these tribes that we speak of, they are not imposters or encroachers in the forest. These are communities that have lived and grown up with animals. Theirs is, if you ask me, the finest example of a happy coexistence, right? They are not the poachers, to my knowledge. I know of the Soligas in BR Hills and many others whose entire lifestyle is in harmony with the forest around them. Animals, of course, but also forest produce, the vegetation, the medical systems that develop there, etc. But by the introduction of this act, what you really did was, and the governments across the world love doing this. Take our own examples. The cleanup of an electoral roll, the proof of your citizenship in Assam, are you Bangladeshi or Bengali, etc. The moment you get into this game, you get into very serious bureaucratic red tape. And I know I'm doing cases in the Supreme Court relating to the Assam tribunals, foreign tribunals, etc. We know the ground realities of these difficulties that our people face on a daily basis. So all of a sudden now you expect tribal communities to come up with paperwork, and trust me, it's very hard to convince an officer that you have the paperwork. If one of us was asked to convince an officer of our citizenship or ownership, I don't know how quickly we'll be able to get our files together. Now, basis that, all of a sudden, a presumption or a narrative was created that there are thousands, if not hundreds of thousands, of encroachers in the forest. So people who coexisted had suddenly now, by some kind of legal presumption, become encroachers. the next thing you know, a PIL is moved in the Supreme Court by a wildlife group saying, get these people out, they're trespassers. To me, there is an inherent flaw in this regime. You're suddenly messing up your priorities. I want to make this very clear. When we speak of cultural conflicts like this, we cannot mess up our priorities. Compassion is compassion for all. And I'm saying this very much as an animal lover. Look at superstition law, for example. And this basically tells me that there's a certain cultural or an urban sometimes elitism that feeds into these decisions. Before I go into the superstition law, the example that comes to my mind is that of horse racing, right? You know that Jallikattu was banned by the Supreme Court. In fact, that was the leading judgment. The first A. Nagaraj case was the judgment that recognized the rights of animals under Article 21. It was a massive step. It's to the tribute of our constitutional jurisprudence that we recognized it, as I said, through judge-made law, not in the constitution itself. But the ban on Jallikattu, again, I think was a hard line. Look, things are not all bad or all good. The villainizing of the local communities that are involved in Jallikattu cannot be an extreme position. Again, these are communities that live with and love their animals, right? For them, Jallikattu is not a license to torture. Trust me, if somebody is so perverted that they want to torture an animal or a human being, they'll do it anyway. Every day I read about humans chopping up their spouses and their lovers and so on and putting them in bags. So no law has prevented it. Yes, in Jallikattu, yes, in the treatment of captive elephants in the temples in Kerala, etc., there are abuses. So in Jallikattu, to have the bull run faster, yes, you have it being fed alcohol, sometimes spice being rubbed into its eyes, private parts, all deplorable practices. That's where the law must step in. But this prohibition business has a very different cultural impact, because what it does is it tells a community that's been practicing this for tens of years, maybe hundreds of years, that all of a sudden your cultural identity doesn't exist. We have to think about this. How much that does for the animal, I'm not sure. Does it not, in a sense, antagonize the local communities, sway the animals? And to draw the example, I want to speak of horse racing. Are you telling me horse racing is not a violent sport? The kind of injuries that race horses suffer, because not just of whipping, in fact, whipping is the least of them. Horses like the Mashir have a strong hide. But, the mouth guards, the reins, the exhaustion, etc. They are brutal instances of horses being very, very seriously injured, ill-treated sometimes. But we haven't thought of banning horse racing. If anything, here's the irony, that the only sport in India that you can actually bet on or gamble on is horse racing, which has been upheld by the Supreme Court because it was treated to be a game of skill. Well, cricket is a game of skill, but I can't bet on cricket, right? And now with Dream 11 gone, that's a different lecture in itself. But you could not, and you cannot, other than horse racing as a sport, under Indian law, bet on any other game of skill. I cannot bet whether, Kohli would score 3200s or not. It's done all over the world. So this is again a cultural issue in my mind. It's an urban elitism. That horse racing chalega, on horse racing betting chalega, but Jallikattu doesn't sit well with our ethical positions when it comes to animal rights. And as you know, I think to the credit of the Tamil Nadu government, they took notice of this. They brought in a special set of Jallikattu rules to deal with the issues and at the same time conserve the practice. And I, at least for one, belong to that school of thought that banning, prohibiting, extreme action will remedy things. No, it won't. I mentioned in passing the superstition law, and I want to use that as an example. Again, a very welcome development. Karnataka, my home state, till I moved to Delhi, has had a rich tradition of rationalist scholars, some of whom have lost their lives for being rationalists, right? Including Professor Pansari, Professor Kalburgi, later Gauri Lankesh, etc. Now, the rationalist doctrine is well taken. The ban on superstition, black magic, blackmailing of innocents, etc., is well taken. But often the devil is in the detail. And now, in these superstition laws that you have in some states, you have provisions, for example, against self-piercing. Now, I have a tattoo on my arm. I can get a tattoo. You want to get a nose pin or a lip ring or an eyebrow ring, you're welcome to do it. But a certain community that has had a tradition, say, of tattooing or of piercing, is suddenly now illegitimized. Is that the intendment? That's again elitism of a certain sort. It's an urban elitism. हमारे लिए चलेगा, उनके लिए नहीं चलेगा. उनको समझ में नहीं आता है. It's not self-harm for me, but it's self-harm for them. And I concede that the law must step in the moment there is harm, either to you or to fellow beings. But short of that, you cannot get into moral policing, puritanism, and this elitism when it comes to lawmaking. So that then brings me quite naturally to the issue of street dogs, right? And before I go into that, I do also for a moment want to talk about, food choices. I mentioned to you earlier the entire beef ban episode. And one of my dearest friends, Philip Wallen, and Misha, I don't know if you worked with him, if not, you'd like to. He's an Order of Australia. And one of the strongest voices when it comes to the vegan animal kindness movement in the world, Philip Wallen. And I've had the pleasure of listening to many of his speeches. And when you listen to him, you will find it extremely difficult to stay non-vegetarian. Because he challenges your conscience so much, and he shows you exactly how the food industry, the slaughter industry works, that it will give you sleepless nights. And I have personally faced those ethical challenges. There are times, because of Phil and others, that I have slipped into being vegetarian, but shamefully I have slipped back to being non-vegetarian. I'm not proud of it. But the point is that these decisions that one makes when it comes to food choices are personal, they are ethical. They cannot be driven by some kind of puritanism. They cannot be imposed on you by saying that this is what our caste beliefs propagate, this is what our religion propagates. Because the moment you do that, as I said, the animals become the collateral. The animals become secondary. It's no longer about animal rights. It's more about some kind of religious imposition, or, for want of a better word, a sort of a cultural imposition on fellow beings. And that to me can never sit well with the idea of animal law. It's important, at conferences like this that you discuss this threadbare, because really we don't have one animal law regime in India. Hopefully by the end of this, you'll have a white paper on this as to how long are you going to depend on Article 21? How much can you stretch 21? Do you need a constitutional amendment for animal rights? If not, what sort of legislation do you have? And I'm sure you've gathered already from what I've said that it's a bit of a mishmash. States seem to have their own laws, right? Prohibited here, not prohibited here, permitted in X state, penalized in another. That's hardly the kind of legal regime you want to deal with. If we are dealing with something as important as the rights of our fellow beings, then you can't have horses for courses. It's a bad pun, I suppose. But you can't have horses for courses. You must have a far more integrated shall we say, a nationalized approach to it. And here come the dogs. Look, the order of the Supreme Court, again, as I told you from my experience with the tiger matter, triggered by good intent. That's not enough. I live in Nizamuddin in Delhi. I love dogs. I cannot step out of my house under fear of attack. In daylight, and I don't threaten dogs, by the way, I step out of my house, or any of my neighbors step out of their houses, walk even 30 steps, they are bound to be attacked. Dogs are territorial. I don't know what's driving that aggression. I moved there about 4 years ago. I've done nothing to upset the apple cart other than maybe intrude on their territory. But this is a real problem. Everyone in my building has been bitten. It means nothing to say that the dogs are vaccinated and therefore are not a rabies threat. Rabies is not the only problem with dogs. There are other real problems, right? The example the Vice Chancellor gave of a specially abled student, of an older person, of children being mauled by dogs, these are real problems. They are not just rabies issues, right? But that said, again, taking extreme positions, assuming that all dogs are aggressive, all dogs are rabid, etc., is not the way forward. So you went from having thousands of dogs, many friendly, many lovable dogs, happily living with their neighbors, with the folks, being asked to be shifted to shelters. Logistical problems there, you don't have enough shelters, you don't have funds. The state at those shelters is miserable. Trust me, what happens to those dogs there, you don't even want to know. And you have the animal birth control rules. Perhaps the most pragmatic solution in the circumstances, which is to neuter dogs and let them back. But again, as with most things in India, suffering with serious implementation issues. And because of which, extreme reactions from the court, every action has a reaction. The matter being, I don't know what, I'm not doing anything. The matter being moved then to a larger bench because of the conflict that subsisted. I don't have time enough to go into the issues of conflict, but only to say that ultimately, in this ad hoc regime of animal laws, one is dependent but naturally upon causes that go to court and the reaction of respective benches to those causes. And that leads to a very different sort of, uncertainty in the law. Rights are perpetually being balanced, tossed around. At some point, animals have the lead. At most points, humans have the lead. But that's not a comfortable place to be in. And that cries out, therefore, for some sort of course correction. Sorry, what is this? Maybe it's my cue to stop.
No, absolutely not.
Yeah.
What is this?
Right. Anyhow, as you know, I have a flight, so I'm going to make this not much longer. I was on this issue, and now with the larger bench's order, with us, in a sense, a happy status quo ante, you've got a position where dogs would be sterilized, returned to their habitat. Of course, in the process, there is a little catch in that order which said aggressive dogs will not. Now, who's to decide that concept of aggression? Whose perception is it? Is it the municipal council workers' perception that A dog is aggressive and B is not? And the process of catching dogs in itself is quite cruel, it's quite violent. The collateral will be there, there's no doubt about it. But the point is, we can hardly see any of these issues in silos or in extremes. Again, this elitism of some sort. I mean, the people crying out in support of street dogs didn't raise a little finger when it came to a million other socio-political issues in my city, right? They seem to be tone deaf when it came to minority rights or queer rights or women's rights. But suddenly this doesn't sit too well with me. If you're speaking of a culture of compassion, a fundamental duty, I think that culture should be across the board. It should be genuine compassion, not fair weather, not in extremity. And folks who are adopting or buying Saint Bernards, I see Saint Bernards being walked in Delhi and Bangalore at 38, 40 degrees. Exhausted, panting, as trophy dogs. The same folks positioning themselves as dog lovers. To me, there's a bit of a cultural hypocrisy here, if you will. And we must not lose sight of the fact also that in this issue relating to dogs, it was not just the urban elite. In fact, if you drive through Delhi at night, or any city for that matter, your own, you will see how many rough sleepers there are. Homeless citizens sharing a pavement with their children and with dogs. So there is a love and affection and a familial bond there as well. and they may not be the ones who have voices in court, but any such order impacts that as well. When we speak of mental health, we speak of mental health of people like us. We don't speak of mental health of the folks who are under the maximum pressure in our societies, the working classes, right? The urban poor, the migrant labor, and others that I have mentioned. And therefore, when any such issue is picked up, in my opinion, a conversation around Article 21, etc., must be, I think, more nuanced. Must look at invisible India, not just animals, not just animal lovers, not just PIL petitioners or big ticket lawyers. They must take into account many other nuances that come in, and I hope that I've been able to demonstrate through some of the earlier examples the many cross-cultural conflicts that arise. So I think with that I'll stop. Thank you.
Can we say something?
So I get that case you got through that safari case. I know that case, and the Supreme Court order for the only see the safari from the buffer zone area, not inside the safari. That I know. But I want to know, that is, you are told about the tribal communities participation, community that is in Wildlife Protection Act. There is community participation, community participation, and that is one provision is there. So here I want to say that in the great safaris like Sultan National Park in Odisha and Bandipur National Park in Karnataka, there are private players also included in that case, and they got resorts in that case. So why not the court and Supreme Court strictly order for the community participation as in Wildlife Protection Act and Conservation Reserve? There is a strict provision there in 36 of Wildlife Protection. So why not Supreme Court, any court order the strict rule and implementation on that, and allowed this private participation, like in Similipal National Park, Bhitarkanika National Park, Bandipur National Park, and that is in Sariska National Park. So these are the questions about you, because you have the practical knowledge in the court.
I think the community participation is very welcome.
Yeah. But I am going to the Similipal National Park. They are not able to, that is community participation in very strict manner, because there is many private players.
Maybe you can take it up as a PIL then. It seems like a good
Yes,
cause. No doubt. But again, when you said resorts, etc., there are different types of resorts. So when I've stayed at Ranthambore, I've seen people who come to resorts there don't even come to visit the forest. There are DJs playing music till 1 a.m.
That is I also go.
Right? But I'm very proud to say my home state is an exception to that. I don't know what that comes down to. It comes down to the sorts of officers, I suppose, forest officers and others working there. Those private resorts essentially attract safari lovers. And they've done a lot to further it. If you didn't do that, you'd have a government monopoly. You'd only have a government resort there and nobody else. I don't think that's necessary. Yeah. Yes, please. Yeah, at the back, I think that's it.
1 second, we just.
Good morning, sir.
Yeah.
So, if you see the current legal regime,
Just step up a bit, please. I can't hear you.
Yeah.
ले ले लीजिए. ले ले.
क्या हुआ है?
जी बोलिए.
good morning, sir. As we know, the current legal regime that we have, it is suffering from legislative interference. So if seen from an ecological viewpoint, the value of life of a tiger is much more important than the life of a human being in terms of ecology. But sir, if I happen to kill a tiger, the maximum punishment that I get is 7 years behind the bar and 25,000 fine. But if I kill a human being, then I might be hanged by neck till death. So, sir, please shed some light on how to deal with these kinds of legislative indifference that we have in pertaining to wildlife preservation, because preservation of tigers and hyenas is much more important than preservation of human lives at this juncture of climate cataclysm that is following us.
Now look, I don't mind a 7-year conviction for a tiger killing, but show me how many have taken place. It's almost impossible offense to convict. Very rarely do you find these offenses. In my experience as the additional AG in Karnataka, and I was doing a bunch of cases that involved, the poaching of tiger skin and so on. It was an impossible task for the officers to take forward. Either there's apathy or there's lack of evidence, or from what you said, a lack of priority. Courts may not take these offenses that seriously. So then do you need special wildlife courts, for example, right? You said death sentence, etc. But look, that's again going into extremes. I do a fair amount of death penalty work. We're all working towards, if not undoing, to the largest extent, mitigating death sentencing in India. So it's a question of priority. But the problem is not in these examples. The problem is in some of the others. I think you know that under the law, there is also a provision for vermin to be killed, basically, legally killed. And that rodents, yes. Now, please go and look at the list of vermin that the government has notified. You'll be shocked. In some states, nilgai, beautiful creature. The macaques, which are themselves on the verge of extinction, in some states, are treated as vermin. And that takes me to the next question, right? I forgot to make this point, which is at one point hunting was not only legal, it was romanticized in India. You go to art galleries, you'll see photographs of people standing on a leopard or a tiger. That's how ridiculous it was. But that shift happened in the 70s with the wildlife laws. And suddenly something that was legal, like smoking in public places at one point. People would take pride in blowing smoke in your face, right? It was fashionable. It became illegal. It became a sort of social taboo. So these things take time, right? What you're essentially saying is one of priority. And for me, it's not so much a question of whether the sentence is enough or not. For example, cruelty to an animal, first offense, I think, is 100 rupees fine or something. That's the joke. You need to course correct those things. But ultimately, I suppose, from my experience, any law or any reform is only as good as its execution. And unless you can then get sensitive and specialized bodies on the ground, officers, communities, right? Special courts maybe, and through conferences like this, lawyers trained in these laws to have that sense of empathy, that might be, the better solution.